Hola, boas tardes.
Good afternoon. Good afternoon, everyone. Let's continue the session. We're going to invite the and let's start the afternoon session and continuing the session of the morning.
Estamos ya. Perfecto. Pues muchísimas gracias. Antes de empezar,
Before to start this panel that we're starting, we have this in this format and this agglomeration in the space of each one, and we have to thank the PACT to be able to approach the strategic Ibero-American dialogue. I would like to thank the PACT and also for the Portuguese Minister of Justice who gave us this space to use so we could have this Congress. The matter is quite long. We have a very wide debate with more than 2 hours of debate. And in the first place, I would like to place behind, just besides the theoretical part, my personal view about what we're going to debate and the people that's going to intervene in the space. I do not know if we are already with Mr. Jorge Abad, the president of the Ibero-American Public Prosecutor Offices, and also Mr. José de la Mata, a national member of Spain for the Eurojust, and Mrs. Rosana Moran, fiscal of the International Cooperation of Spain and General Secretary of the Ibero-American Association. So to start, there has been some years of experience in this matter, and I believe we can bring to this panel as well. There's a certain predominance in the ages of the debate, so I hope it's not similar to a bubble. And there are some points that we have to work. Last year, during the pandemics, the PACT approached the elaboration of a report that was quite long due to its dimension in number of pages and also the contacts it made to obtain all the material about the problems of the Latin America, the functioning, the rules, and also the joint investigation teams. This report is not as wide as this one that goes into specific relationships that can have a certain focus on the investigation teams. This report has a set of conclusions till what extent the tools are adequate tools to fight against the organized crime in Latin America. And there's a certain diagnosis about these tools, if it's being underused due to its potential and used by two institutions that have great weight when it comes to define the future of these investigation teams. On one side, CONGIP that has under its responsibility the initiative about the specific milestone about joint investigation teams. There's a lot of conventional rules and do not come in more specific rules. And also in the part of IM, more specifically in 2019, when it was spoken that one of the most effective international tools for the coordinated investigation against organized crime, also signals the deficiencies that exist at the national level that difficult their functioning. It would be necessary to evaluate at each country. There's a coordination among the ministers of justice that have been developed during 2021. We are working here in line with CONGIP. In Spain, it has a leadership position to improve the identification in the deficiencies of the international rules, and also works as one of the tools to potentiate the conventional rules. More specifically, meeting a convention of investigation teams that, together with CONGIP, we might be able to get a larger number of ratifications. Ecuador ratified this agreement lately. It's not in force yet, but it's inspired rule in this kind of rules of convention. And this convention that we hope to be in force soon. Also, it's working in a part about joint teams, the operative part of good practices, transfer of knowledge, the concrete details, and not just those that come in the legislation, but also those that exist in practice and should be operated. Before ending, and ask for the first opinion of our panel, there's a set of practical difficulties that are very relevant in the Ibero-American region, the lack of knowledge of the tool of joint investigation teams, both the lack of the knowing about the tools and the practical details, to what extent this investigation team might be unknown or won't be put into practice, and if the approach is the ideal one and does not have the convenient measures nor the required support. It will also be required the trust in among the joint investigation teams, not only among countries, but also among institutions, and also the difficulties for funding. The recommendation should be to strengthen, to harmonize these rules, to train juridical operators and also networks. And I would like to debate a bit this topic. Anyway, this is the opinion of a specialist team, two Ibero-American institutions. What is lacking today is to introduce the existence and what is the dynamic that we could have in these joint investigation teams from a European perspective within the relationships with the Latin American countries. One of the most important points shall be on the table. What is the strategic perspective that this group might bring in relation to the joint investigation teams as a joint team to be able to fight this kind of crime? Without further ado, I would like to start and would like to know a bit more the opinion of the panel regarding these matters. I would like to welcome George Abbott.
encuentro de instituciones europeas y Latinoamérica. Un tema tan importante como este en las dos regiones. En primer lugar, quisiera manifestar la de la
I'm sorry, but the sound is not good enough to be able to translate.
de la figura de los equipos de investigación. Y este es un tema que evidentemente hemos sostenido en nuestra institución y hemos incentivado su uso y tratando de superar las limitaciones que tanto en la normativa interna como internacional existe sobre la materia. Sin duda, digamos que la efectividad y la utilidad de los equipos conjuntos de investigación son evidentes. El tener un mecanismo que permita, ¿no es cierto?, abordar de forma.
We shall try to do our best to have a mechanism that will allow us to improve the connection at the international level. It's a difficult challenge for our institutions, for the different public prosecutor's office in the different countries. If we can unite ourselves, we will have greater impact, greater efficiency, and we will be able to investigate the criminal phenomenon in its whole complexity and integrity that today is manifested in many ways in a transnational way. The international criminals have the advantage of acting in an efficient way to several delegations, and the disadvantage of those that do the investigation, it's when these criminal networks act at international level, they have a benefit and we have a difficulty. So it's also about we need a flexible tool. If it's efficient, will let us act in that sense. We need a tool, as I said, that should be flexible and that we can amplify it slowly, including other investigation areas as we see the preceding actions of the investigation, etc. And this is the Ibero-American countries, the good use of these tools, so that in our meetings or in our teams, we have urged the different countries to be able to simplify the frameworks in order to be able to support the institution with the set of instruments. For instance, in AIMP, we have shared the set of instruments such as the Agreement 4 from the South America that started to be in function this year and gave some fruits already. And we also work with IAMP in initiatives that are to support and useful to form, to train joint investigation teams from in the Ibero-American countries. We started this in 2018. One which is a step-by-step application how to build joint investigation teams. And also, we have prepared an agreement for the constitution of a team. It's a convention agreement that has been used in several joint investigation teams that have worked in the Latin American countries. And we also have, at the level of our institutions, started to constitute for more than 2 years joint investigation teams. Of course, we face challenges. Those are the regulation frameworks, not only internal of each country, but at the international level. But we have to evaluate the creation of this kind of meetings. Is very important, the transfer of experience, of knowledge, and from Eurojust to Latin America, in which the trust spaces, it's a point that we can talk more further ahead. But this was my intervention that I would like to give you, and then we will approach specific points if the facilitator so feels them fits. Thank you for being with us. If you feel it's okay, we would like to know how Eurojust, in terms of cooperation, executive cooperation, can intervene in this issue of joint investigation teams, thinking in the scope of Europe and Latin America. Good afternoon, Mr. Rosano, Jorge, Javier, thank you. To the Pact and the Ministry of Justice of Portugal for their kindness to give us a space for Eurojust in the conference, and for the strategy that we have been showing from our agency. As we saw this morning, the words that the president of Eurojust addressed to this panel that could not be here personally due to other commitments, the proximity of Eurojust to the objectives of the conference, to the objectives of the Latin American networks that are here present, is undoubtedly important, but it could not be here. And we have two representatives here of Eurojust. I'm very pleased to be here to try to solve any doubt, any problem about the potentialities of the agency and the possibility of working together with the agencies we have in the different countries, Latin American countries that have international character. Javier, please give me just a few minutes so I can explain a bit more how is this relationship between Eurojust, which is a European judicial cooperation agency, together with Latin America. The basis, what is the construction, how Eurojust can bring to the investigation. As the president said this morning, Latin America is a very important area for Eurojust in a strategic way, an operative way, and this translates into concrete elements in the strategic scope, because it includes the strengthening of the cooperative cooperation with Latin America, and due to this reason, among the countries that in the next years will sign agreements, we have already Argentina, Brazil, Colombia, and we are taking the first steps to get to this cooperation that will allow us a permanent cooperation and systematic cooperation among our countries. But besides this, there's also a second level of cooperation, also at other strategic level, of the assistance of contact points with the countries of Latin America. As we saw with the support of El Pacto since March of this year, and we are working and we have been working to appoint a point of contact in the countries of Latin America, to have a communication channel among our countries. In this sense, we have some contact points, not to forget anything: Argentina, Bolivia, Brazil, Chile, Costa Rica, Mexico, Panama, Uruguay. These normally in the district attorney office, but we also have bilateral meetings with the support of El Pacto and of the prosecutors' office of the different countries. and so we can see the relevance of appointing the contact points that allow the opening of this relationship. I cannot stop here. It's important to outline at the end of the day, we have been receiving from our relationship, and we have to pay attention to keep the standard of rights protection that now are interesting and include the intimate part and the data protection. In this sense, the point to be emphasized is that without any prejudice, at this moment, we might not have yet a permanent agreement that has been signed of work between Eurojust and the Latin American countries. But this operative collaboration translated in the interchange of data can be translated case by case and analyzing case by case, and also this juridical collaboration, the non-existence of these agreements. The non-existence should not be seen as an obstacle, but also as presuppositions where there's commercial interests among the Latin American countries, the tax authorities in Latin America and the countries in the European Union. If there's a will, there's a way. And if you can see it case by case, to get to this collaboration and to this interchange of data, of information, and what is interesting for us particularly, to constitute joint investigation teams.
As you know, the joint investigation teams don't have a specific purpose. Our idea is not to make an investigation team. They're more a means, a tool, and for that reason, in the same way that no one uses a tool for a different purpose from what it was designed for, investigation methods are also the most suited tool for each case. We need to take into consideration two instances. First, do not use teams when we don't know what is the real situation, but rather when the circumstances require. So each case to be investigated in 2 or more countries in Europe, and when these countries require or request a team under these circumstances, and then do not have reservations or fears, and that they can use this tool without fear. So do go ahead and analyze and try understand and how to overcome these hurdles that will enable us to reach the making of this team, and when these circumstances are complete. So this will be the best investigation tool to reach our objective. So it is important to mention here one statement that an investigation network produced, a companion from or a colleague from Slovenia. I will share with you. He used to say, joint investigation teams have some strong ideas. They amplify the perspective of a fiscal and an investigator. When you work with people from different origins, we understand better why they execute a certain type of measures and why they can't execute others. The best added value to a team is the creation of mutual trust as the basis for close cooperation. An agreement is a contract that is designed to make your investigator's life easier. I think this is a simple sentence, but which reflects quite well the purposes of teams and how they can help in managing a concrete case. And this introduction leads me to some references to some general ideas. For instance, for me, it's important when we talk about a joint team, we see the international or transnational part, but do not forget about the relevance of joint teams nationally, with much less obstacles and difficulties and logistics, which is easier. And so they make a powerful tool to move on with complex investigations that naturally always require the articulations of multidisciplinary teams. We move forward at national level. We need to look for the protocols, and not always are they elementary. That is, teams that, that we can make up these multidisciplinary teams of joint investigation, experts, institutions that can help in the investigation, always on the investigation and the juridical part of the investigators and the fiscals. In most cases, they make up a differential element, which is different from the investigation that we are trying to achieve.
Naturalmente, los
Clearly, the tax officers or the taxmen are the authority or the leader of these teams, and they are the ones that set the objectives. It is important that they can ensure that all requirements of the process are complied with, and that they also comply with the agreements. When this happens in a country where the central authority is the public prosecutor, then excellent. This convenium or agreement simplifies this management. But when this does not happen, the incorporation of the central authorities, not the investigation team, something which is strictly juridical and judicial, but in this preparatory process that facilitates the work, the logistic works and the administrative, contractual work is extremely important. And to have its non-inclusion in other words, is a major obstacle that can ruin the success of this operation. As we are here, investigators strategically talk about the implementation of this team, but we also must take into account that central authorities are important, extremely important. In cross-border investigation, time, swiftness, and efficiency are essential. First, why? Because, and secondly, because many organized crime organizations, while we are speculating about the crime, they keep on practicing it. While we talk, there's many cases in many countries where you have time limits for the development of this investigation, namely to formalize the crime. Swiftness, efficiency, time is of the most importance. The planning of investigation, the noticing of the existence of an international dimension, a fast decision-making, and what is the most appropriate tool These are the imperative needs that judges and the taxman needs to take into account immediately. So whenever there is the moment for the study, in a more abstract and wider moment, that so that we can articulate the mechanisms, putting each at its level so that at that time we manage to do it in a quicker way. And quicker because in this case it's the making up of teams, and once they're made, then we can exchange information in real time. And here we see an important idea that emerging that I would like to highlight. It's basic at an European level, and we can use it in terms of joint teams that could be of a cross-continental nature and in European nature as well. How can I express this idea? The idea, well, I would try it this way, that each one manages to be concentrated on his or her own essential interest or objective. And what is the objective of the investigator, of the taxman, of the judge? To plan the investigation, to make decisions at national level, to define the purposes of the joint team and decisions that need to be made. And when you don't have an objective, that is, we lose time with logistic, contractual, administrative tasks, and so forth. So what is the correct decision, therefore, within the scope of the European Union, and therefore in the relationship between Latin America and Europe in this scope, to use for these tasks specialized staff whose mission is to co-help with the taxmen and investigators to facilitate their lives. So the recommendation really, it actually is this, that there is a trans or a national or continental mission where we appreciate the need of making up quickly a team, and we need to quickly incorporate specialized staff into this team that can help within this scope, administrative staff, contractual, so that the tax people can concentrate on their role. In European Union, and I will quote here Eurojust, to personalize this support. That would be one of the challenges, to set networks of joint research teams, to set up national teams networks with experts for assistance. In this debate, my recommendation, well, for this debate, if there is a cross-national interest, please feel free to communicate with Eurojust. We will help in our branches in each country, and we'll help in the making up of these joint investigation teams. I don't know if I have a few minutes. Okay, so this leads me, after spreading about this conclusion for a while, what are the challenges then? It's another point. How to create a relationship with Europe, and conclusions for recommendations, especially in the documents that we have worked until we got where we are now here. We need to analyze these recommendations on joint teams for Latin America, and there's nothing better than to highlight the challenges that the European Union has identified on this subject. How is the situation in each region? Which comparisons can we establish for this debate? The certain thing is that if we analyze the challenges of the making up and the development of these joint teams from Europe, we are not that far away or far apart. It's true that we have lots in Europe. In 2020, namely during the pandemic, we had 270 joint investigation teams, nothing exceptional. It's more a mechanism of assistance that it's well greased and that can reach objectives quickly. Which objectives? Well, sometimes the lack of investigation makes it difficult to identify the perimeters of each case in the different countries. Second, the differences of national legislation, where in some occasions, well, they can create some problems in on the making up stage of the joint investigation teams, sometimes minor problems, but time-consuming when we talk about teams with 4, 5, or 6 countries to circulate papers through half the continent, to obtain signatures. With the pandemic, unfortunately, this helped these delays. So now there are other ways of signing these documents. And also the cooperation of third states that I'm sure will address that issue in this debate. Which challenges are we finding? Well, the existence of investigation within the teams themselves that are uncoordinated, not by lack of information, but of coordination. Also national legislation on ways on how to incorporate into the process the evidences that are obtained, and the way to document the process, all the history of the joint team from its pre-makeup till its final dissolution. And so the incorporation of these new countries and states to these investigation teams, well, we could have a third country coming in, or mechanisms that interchange information or data on the investigation, or third countries that are not even part of this investigation team, but that are related to the case, but for some reason did not subscribe this investigation team, but they do have a material and procedural bond with this investigation and its purpose. So these are some of the challenges, and to end, therefore, of these challenges and the way they are approached and the path that has been treaded so far, and what steps have been taken, and what can we learn from them. Please pay attention. The first one is so obvious, and we take it for granted in the European Union, that probably we don't even realize its full extent. And for me, it is one of the most important. It's the institutional structure on which all the development of relationship is based between the tax offices of the different countries. What do I mean with this structure? The very agency, Eurojust, that offers fantastic support to these operational and logistic issues, and that also opens spaces for dialogue and communication to the different bodies and forces of the the tax officers part of each country, the regional network, and thirdly, the national networks of experts in the joint investigation teams that follow these investigation teams. That is, there is a follow-up, and it is quite frequent in Spain for a judge that will conduct an assessment of one of these teams, and it's their job to evaluate a colleague in a point, or that they even are consultants to Eurojust. There is a follow-up here that quickly that we can manage for this tax officer to leave behind all the administrative, contractual, logistical aspects to these assistants or to these experts. Secondly, the institutional investigation, the best practices. Please allow me to stress once more the role of Eurojust. The administrative and logistical part avoids the tiring of tax officers and judges, and therefore we prevent them to be missing or lacking energy so they can focus on the most important issues. Secondly, are the operational issues. I would mention the most important one, the importance to manage expectancies with a good preparation of the case. Secondly, the clear formulation of the purpose for the team, for the joint team, to fix the objective for each team in each country that are part of this investigation, and the investigation plan that will be adopted by all the countries. This plan, it's also important that it is well documented. It should be documented. You must have an agreement on this investigation plan. Thirdly, not to limit the makeup of the team to the making of the document, but rather to create a pact of common strategies that will be implemented, and in this way to guarantee the proof, the feasibility of the evidence, and then therefore to avoid jurisdiction issues too. I'm told that sometimes it's better to have 50 reds than 10 yellows. At this stage, it is important to fix the accords that will soon be developed. Sometimes they can even be incorporated into the very contract. They don't always have to be documented because of an issue of reserve or any other question. And then finally, to include the willingness to guarantee the sharing of information of third parties, parties that are not bound to the investigation, because there are some parts of the criminals that are in their own territory. Just to add a minimum or minimalistic reference to work that is being conducted right now, and I believe it will be very useful to move forward in this field, which is the making or the constitution of the collaborative digital platform for joint investigation teams, a whole computer system, a portal, so to speak, of joint investigation teams that will enable that each stage and preparatory stages and execution stages, and the exchange of evidences and the assessment or evaluation of teams, the findings, so that all can be conducted in an easier way than what we have seen so far. So I think right now I've spoken enough, but I'm sure that we still have some time left to have a debate, and we have some time here.
Apuntada.
There are all very important themes, and we should approach them in more depth. And then I would like to ask Dr. Rosana Morin, to do its presentation from the European institution and Latin American. I believe that you have play a very central role, because you were a lot of years in Latin America, and you've been in Europe, in Spain. Thank you, Dr. Xavier, and thank you, El Pacto, to do this conference, because it's a very essential topic. I am amazed to share this with the president of AIMP, my president. We started together the promotion, and also to be able to be here with Dr. Xavier, and the topic couldn't be more interesting than it is. And many of the points that are a challenge to us have been underlined already. So my mission is based on the hope of improvement. Based on my experience, it has been very deceptive till now, but anyone that sees reality, that the joint investigation teams already exist in the convention since 1998, and we are in 2021, still speaking about the problems about the constitution of those joint investigation teams. The launching that's in the Convention of Palermo, Merida, about corruption, the exiting, that was the framework of 2013. It was the European Union that launched this joint investigation teams. And in the EU, we have had difficulties, and as we overcame them, we have been learning, and thus Eurojust was a fundamental tool in terms of the aid, the logistical help and financial help that it gives away. It's essential, because the joint investigation teams have to get together. So this means traveling, etc., expenses. So in Europe, we have translations, we have traveling, and also we also have the knowledge and how to constitute this joint investigation teams. But till now, I can say that outside the European Union, to create a joint investigation is terrible. It has been terrible till now. My colleagues know that very well, that because of the difficulties of the national legislation, the deficiencies that we have in the national legislation, all this came up to the light, and based on the claims of AIMAP, we need this kind of tools. We have been able to drive some, boost up some of those requirements, because in Latin America we have a convention of 2013 that's still in force. That still is not in force, although it's an excellent convention, it's still not in force, and it's a shame. It's terrible to create a team So AIMP offered to all the prosecutors of Latin America, not all, just a guideline of all steps how to create a joint team, either a police one, investigators, and I'm not just talking about central entities connected to the justice minister, but more than that, we have created this guideline to help the people to create these teams. And we have created also a model document based on the EU document so that we can create those teams in Latin America. But it's not easy. It's a very useful tool. We cannot wave them away, but their constitution is very difficult. And there's still a lot of things to be improved in the internal legislation. In reality, Spain, it's an example of bad legislation. We are trying to improve it, and I'm sure that we will do it. And inside the European Union, I'm going to be very practical. There are certain things that were referred by Dr. Jorge. The importance to know what these joint investigation teams are for. In most cases, these teams coordinate parallel investigations. It's not only when a state needs of the cooperation from another state. Normally, the joint investigation teams are constituted when there are parallel investigation of 2, 3, 4 international organizations that have tentacles in in many countries. So we need that this competition between jurisdictions, not only regarding one fact, is done in a coordinated way. And I think that in relation to this, we all agree with the same. But how to coordinate? Maybe it would be easier to do that through joint investigation teams. In South America, it's easy. The Eurojust helps to do that. But in Ibero-America, that's fundamental. Another questions that we have conceived here, I'm referring to this issue, the work of a legislator. Since we have started to work with joint teams, we have noticed the lack of internal legislation, not in the constitution, the function, but the inclusion in the process. As Dr. Shaw said, we have no regulation in Spain. There's no regulation about how the joint investigation teams are included in the process. And here we are going to have more headaches and more problems because there's no regulations about how the defense works in these teams. For example, in Spain, who investigates is the judge of the instruction, and it's part of that. And that doesn't happen in other countries. It's the prosecutor who investigates, and the judge is only the guarantor of the law, and the investigation judge is out. So I think this is an important point in regulations, all this regarding the procedural system, and also to regulate the material, the inclusion of material. How is it included, all the things regarding the custody, and then we are in one country and we're going to investigate in another one. And one thing that's very important, the origin of the creation of joint teams that's still not solved in Latin America. Which country is going to do the inquiry? For instance, one thing is to investigate coordinated parallel investigation, to articulate and coordinate the investigation so that it does not raise awareness in another country that this is going on. But then we have a series of fragmented investigation. Each one does each part, but that doesn't lead anywhere. So, for example, in Spain, it was impossible to sentence the chief of a criminal organization because the organizer was in Italy, but the organization was in Spain, and so we could not do that. So it is important, the regulation. It's a point that has to be, in my opinion, has to be included somehow in the conclusions, how to solve in Europe the problem of jurisdiction problems in South America, and when the joint investigation team ends, how is they going? The audience is going to be carried away, the judgment, the trial. This is an agreement that can be done, or if it's an imposition, and then the criteria, which criteria to make the definition to say, oh, this country, so and so, that is going to have to be punished more heavily, the crime that's here in this case. No, this has to be approached in that cooperation. And I believe that all these practical questions came up after the progress we made, because I said, oh, it was terrible. But after all, we had been able to constitute some joint teams, not much, but some. For example, Argentina, Spain, Italia, with the help of Eurojust. I'm speaking about intercontinental teams. And I think that it's necessary to have regulation either at intercontinental level and Ibero-American. And then we can maybe form a joint team, because it has been quite an ordeal to be able to do that. And I just put here on the table the conflicts, the role played by the defense, also in Spain till now, many times the defense is a bit put aside. What's this of a joint investigation team? I don't understand. Why didn't anyone tell me anything? So they haven't been able to participate in the investigation. And in many cases, they had the reasons to do that. So the accusation, when there are accusations in those countries that admit particular accusation, in the case that they accept the private collaboration, there are many procedural issues and the proceedings and all that is related with the constitution of joint investigation teams, and I think we should approach that too. Thank you, Rosana. I think that you have just referred some issues that I had in my mind, but now are on the table. So my first question. The first figure came up in 1988, and then you went through that ordeal and you were able to form some joint teams. But now at the place, we're going to talk about that. The Minister of Portugal spoke about this morning. The General Secretary of this conference spoke about that. So other people also talked about this. Is it because we have been able to advance and to create some joint teams that we are going back to the same issue, or is due to all the difficulties that you have been through all these years, and then you have joint instruments because all was due to the pandemics that you were in, how this came up? I have the feeling that because we started to constitute some work well in Europe, essentially with the collaboration of Eurojust, we have teams that are successful, and we have some experience, and as someone that knows that experience obviously has to use it, but we have to improve both the way of constituting them as well as its regulation. For some time, the tax officers have been using it, do not know very well, but somehow we would like to alert for the use of this instrument and to push to the legislator to improve the rules that help us to work for this in this sense. And normally I talk about joint teams, not to the police. The because they are easily to be created and are easier to function. But this, at the tax level, it creates more problems, like the lawyers, the competent jurisdiction. I think it's a useful tool that we have to improve, and we have to facilitate the juridical part so that it can be used following previous examples that would not lead us to go through another ordeal as we have been through. I believe that Spain, for example, and you know very well because you are at the Minister of Justice, you are exposed to these projects. We are aware that this is a useful tool, and it's clear that we have communicated several times that the need for a better regulation and the countries that are in the same situation to improve legislation and the internal rules. It's not a secret that the Minister of Justice in Spain has that need. It's included in the annual plan. As a principle, it's going to be started, that resolution, publicly, if not now, maybe next week. And that will be the route to follow. So the diagnosis is to share, but not in a homogeneous way. The report of the impact, national rules, lack of training. We also spoke about lack of mutual trust. So I would like to know a bit your institutional opinion, special to Mr. George. So it's the YUMP reports, this lack of rules to support that potentially in a more complex phase, namely during its constitution, we can get to the point that the team is not constituted, but to get to its purpose. What is the opinion of YUMP and Fiscalia about those deficiencies outside those practices regarding the trust, the funding, the lack of knowledge, training? The obstacles, the important obstacles that we have faced in the creation of investigation teams is the creation of trust. I think that YUMP has to move on in an important way to become aware through the General Prosecutor's Office the importance and the strength it has in this joint investigation team's creation. I believe that most likely because there's the appearance of information, these relationships with the members of YUMP that we are working on. This topic, we have to look how the international legislation with international pacts can be introduced in the rules that will allow to facilitate the constitution of this kind of teams. Besides that, the way problems are solved. There are some issues that are quite relevant that are, for example, the participation of defense. Defense has the right to have access to the information from the first moment, from the first diligence. In consequence, it only does not have access when it's secret investigations. except some exceptions. All the operative problems, as Jorge said, regarding the swiftness in constituting this kind of teams is very important. That information, that participation in the defense. But what I believe the difficulty we have, and I talk especially about the Chilean experience, each tax officer has to gain confidence with other tax officers of other countries, and that construction is where the complexity resides, and therefore the support from Eurojust. There is here a permanent liaison, and it's necessary to create trust so that we can have can create this kind of teams. Latin America, we have this difficulty. In the case of Europe, they might have the same difficulty as we have here in Latin America.
These joint teams that Eurojust can help with, we also have a limited experience here. What are the diagnoses and perspectives that are existing within the European community? They are easy to overcome. Can we learn? Are we going through the same? In reality, if we don't compare the conclusions and the recommendations from the Latin America reports, and if we see the analysis that we have reached in the meetings of experts on joint networks and other types of reports from other teams, then we are in a situation which is close. There are some difficulties here. There are difficulties in Latin America, in Europe for the building up, team building, and there are also fears. But in this case, I think this is not related to trust. It's very pleasurable to say after so many years that it is in acquire, that tax offices within the European Union, and regarding the opportunity of including, well, we could go into unsafe ground if we are not coordinated. As Rosanna highlighted, the difficulties in Latin America are similar to some countries in Europe. I won't mention specific cases here, but it's also true that teams are built or constituted in Spain, where there are some professional categories that are missing, and the lack of proofs for the participation of defense for the courses to be, whether they are secret or not. And so there's always these situations. And it's always important to have an investigation team. When you don't have it, you can avoid the revelation of evidences, and we also avoid the participation of the defense since that happens. What I believe is important is that when you have a problematic ground with logistic difficulties and organizational and legal difficulties, where operators are not truly capacitated, leads to, or it would be very important for that we withdraw this lesson, which is the importance in Europe that it has in Europe, how it would be important in Latin America to make a similar effort for these follow-up structures. In the case of Eurojust in Europe, this is an agency, and there are the different regional networks, the national networks of experts, and they are important when we are facing such a challenge of this nature. In Latin America, everything depends on the characteristics and circumstances, and even the financial capacity, which after all is not that big. I'm talking about a wide universe of countries in Latin America, and they make up an element that can make the difference. The existence of communication networks such as the Eurojust.
Los documentos que estamos hablando se mencionan de
The existence of this network and mechanisms with documents that can be mentioned. Also training, referral, a portal where all this information can be compilated at national level. So we have this model that we'll be using, and everything towards the facilitating. And it is important to focus this point because nowadays and in these past few weeks, with this football spirit, it's important to remember the Liverpool's motto, "You'll never walk alone." It's an important motto to what we aim for ourselves. It's one of the best messages we can convey to our operators. You will not walk alone, because you'll have a whole follow-up structure to facilitate, to guide, which will enable you not to become dispersed, to focus on what we need to concentrate on, and not to fear all these issues we're talking about here, because there will be people even within the national network, in the portals that are made available, that will facilitate this route and this guidance. And I believe one of the most important things in this type of issues is that there isn't a real possibility for this to prosper, because with the amount of difficulties we face, for instance, a taxman who has an investigation with other ramifications and branching to other countries, there he will need to walk alone and will need to develop very often alone and to count on no one else, and to put all these mechanisms into force. And this will be quite, it will make the difference, and we need to be within this idea, because the idea is to improve all of these and to give it our stance and to follow within these scopes. And coming back to the case of Eurojust, in its collaboration in these cross-national and cross-continental cases, I think we could be scoring or making the difference in many cases. But this cross-national or cross-continental, or in some countries in Latin America, there are some different branching of these criminal groups, and it results in a decision to move quickly with Eurojust, so that Eurojust can place these investigators in the corresponding countries and to execute this task of following, to see whether we can process and put these tools into force.
Eurojust en este ámbito, pero la IAM tiene una red.
So in this scope, the AIP as a network, which is directed by Antonio Segovia, who is the coordinator, and there the prosecutors are experts in international cooperation, and they are the ones who have drafted this guide on how to take these steps for the making up of joint teams. So they are a reference in Latin America, together with Eurojust, to create this kind of system. So we'll never be on our own because the network can support us. Yes, there is well, we have a question here. A question from the audience. Well, it's not really a question, it's a reflection I would like to introduce as a sort of a complement, because I won't be adding anything, namely in terms of the excellent presentations we've heard from the people that are on the table, that who are who have deep knowledge about the huge advantages that we should underline or highlight with joint teams. Well, we talk about the spreading or increased delegations. Well, what I will say, it's only my testimony. I just want to contribute with the testimony to confirm the relevance of these joint teams for joint investigation as a technique, because it actually is a juridical or juridico-processual technique to speed up and to make a criminal and penal investigation more efficient. But we need to debroker, to take off the red tape. Because from the institutional point of view and national point of view, I should also mention the importance and the implications of judicial powers, of course, within the scope of their own competencies for what should be the good functioning of courts, and the same in terms of the prosecutor's office. And I'm talking as a representative of an institutional body, which is to involve also the governing bodies that have competencies in terms of international juridic cooperation, like, for instance, with the General Counsel of the Public Attorney in Spain. And regarding what has been mentioned, the need for training, the need for those that will become the main players with this type of tools, that they are able to use it effectively. And the testimony I would like to contribute, not as a spectator, but rather like one of the recipients of the work conducted by the national networks of research or investigation teams. There is a connection from judges, for instance, who are responsible for that national network in Spain, where the governmental body explains all the activities that are developed. And that is a way to, well, they ask us questions and they petition about these issues. For instance, a while ago, because of the pandemic, 8-9 months ago, we defined also a number of duties that the judicial power needs to accomplish. For instance, the need to have presentations or proposals for training courses, the lodging and the information in our web pages, for instance. So very well that everything is on institutional pages, but it's also good that the network itself will become capillarized and that it reaches all its recipients, and that according to the judicial system, the operators can potentialize it. It's very important for judicial powers, as it happens with the public prosecutor's offices, for instance, with the task of disseminating, for instance, by creating information booklets where you have, well, for the judges, probably everything is not that is not familiar with these tools or any other juridical operator, so that they can have some tools to easily access, for instance, the coordinates of Eurojust. It is paramount that that is on the judicial offices, and in our case, that had a very strong repercussion in the culture of these techniques, of course, in its rightful dimension and whenever necessary. In this point, I believe that there is a certain responsibility from these institutions regarding the prosecution or especially to the implementation of training for the recipients, that at a certain time they can use this technique of the team building for joint investigation, because most of all, and besides what is the conventional regulatory framework, which can be more or less complete, because sometimes some gaps may exist in the action that is within the very bodies of the Ministry of Justice, the Public Prosecutor's Office, and different institutions, to have a dialogue about interinstitutional justice that transcends the strictly the strict competencies of each institution. So I would like to offer my testimony of the good health, and most of all the route that we still need to make institutionally for the judicial powers and institutional bodies and the Public Prosecutor's Office and the Ministry to get involved in this role for dissemination, and that they will distribute this knowledge about institutions such as Eurojust, most of all, to have a real culture to facilitate techniques in terms of criminal investigation. Thank you very much. Thank you very much for your intervention. But based on this, and to make this more operational, I would like to, and regarding the last intervention, there was one issue I would like to raise. Dr. José talked about the follow-up. We looked at the attitude of those responsibilities. We talked about the responsibility, but the responsibility of the Ministry of Justice when they have a legislative initiative, if there is no legislation, to create legislation to facilitate the work of the players, and the officers and the institutions need to cover the existing gaps, for instance, in terms of practices or needs for training or financial resources. So with this, we want to develop things not at a tactical but strategic level. I wouldn't like to talk about these responsibilities when they overcome their recipients or the institutions that are aimed. So, Dr. George, in this case, the AIAMP has an institutional role and some contacts with the networks, and if you allow me, namely from the more institutional point of view, this network has a big institutional reach, but some others have an operational reach. So how can the AIAMP thrust or the networks incentivate the good usage of these networks?
Ahora sí.
Perdón.
Ahora sí.
¿Ahí se escucha? Bien. No, refería que
I would like to mention that the AIAMP is right now signaling, and it is making an effort to be in each of these issues and to publish all the regulations so that they can become feasible and possible through international legislation. So it's a theme that is very crucial, and we have a responsibility of needing to create alliances in order to manage to make these regulations and make it flow in an easier way within the joint teams. We could also have statistical clarification within AMP, and we could approach this theme. Regarding the position of Eurojust, and we can have all this follow-up and offer our experience. And from our numerous joint investigation teams that were created with time, and that are so important, and we believe that we have a good route to be able to include also the experience of our Public Prosecutor's Office. We can clearly state our availability and responsibility so that this can stop being, and which is quite important because there is much practice, and this is a challenge that we undertake, and to be able to move forward. Thank you very much. What is the strategic position of Eurojust? We are talking about contact points, different levels that you say they are not an obstacle for those Latin American states that does not have access to each one. But this ladder is part of a strategy or has an impact on this strategy. Yes, of course. As I was saying, there are three levels or situations, not to use this comparison with the ladder, which is not the best comparison. Fortunately, in the next few years, we will have cooperation where there will be an interchange of cooperation. A second one, in the case of Latin America, with an important majority of countries with whom we have contact points that facilitate contacts and cooperation. Where we don't have contact points, to identify where they don't exist, where they can't access collaboration. But of course, they can have access whenever there is a case. What we do is we strengthen this connection, and there will be an opening that will facilitate this communication. And we foster, incentivize all to establish this relationship so that we can help to materialize this communication. And this communication can be open, and it can be established between the Latin American country who has an investigation and an European country that also has. They are both owners, and they are both the officers for the investigation. There is dialogue between them, and they make decisions among themselves and agreements. What Eurojust can do in this case, in trans or cross-national, bicontinental investigations, among others in the European Union, is to open spaces and to clear spaces for dialogue, for communication, to facilitate, not to be intermediates, not to be in between, but to facilitate this dialogue that sometimes, because between Portugal, Spain, and Latin America, it is easy because of the cultural similarities and the treasury, which is, or the treasure, which is our language. But in other cases, with other European countries, it's not so easy when they speak other languages. And there are some difficulties. So all of this first strategic support of Eurojust facilitates the process, and it clears communication space or room for dialogue, like the motto of Eurojust says, to bring people closer, so that dialogue can happen. We have insisted a few times that when that moment comes, the Latin American officers have taken steps to open this path, and they have to concentrate in issues that are not only related to investigation. So Eurojust facilitates support, logistic, administrative, technical, and also assistance, so that the team-building process, not the criminal investigation, which belongs to the authorities, but that it will progress and move forward, and eventually financial support, like Rosanna mentioned before, which is very important too. It's true, that's one of the lessons that the pandemic has taught us, is the possibility to do it differently. What used to be very expensive, and no doubt we need financial support, nothing too big, but nothing minor either, and they can contribute to have an extra piece for the mechanism to function. This is an idea and a strong message that we want to convey to our companions of cross-national investigation against crime that can affect a member country of the European Union or other countries in Latin America.
A good recommendation is to contact Eurojust, and from there we will facilitate a dialogue among the judicial and tax authorities. And if they get to some agreements, there will be a follow-up so that everything that is not strictly judicial can be facilitated from the part of Eurojust. Thank you. We have more pieces of institutionality, some a bit diffuse, and if you allow me, of this strategic nature, what can that point bring on one side? And the other question, to close the cycle, what can bring El Pacto to this process of the joint teams, this tool? I think that we are already giving solutions. We are placing on the table how to move on. We had worked on this team before, and I believe that the follow-up of El Pacto is essential. I'm saying that the theme of joint teams is very old, and if we continue with this possibility, especially for drug trafficking or with the organized crime, these teams have not been created more than 3 or 4 years at the level of Latin America, and that has to do with this team, but it's in the agenda of all the district attorney's office and everything, due to El Pacto that knows very well the European reality, knows the usefulness of this tool. It's within this topic of the work that we are doing, both in the networks and in the judicial summits, within this interinstitutional scope. but also in the works that we have been doing with each institution, with whom we have some collaboration in some points, and we can continue to follow up. And with the conclusions that we have heard here, we can see the needs coming out of this table and can also be used as the guideline for the Aeropact to follow up this process, always with the idea that this follow-up might improve legislation, give more knowledge to the prosecutor's office, and in many cases also because ELPAC is working with specialized networks, for example, the environmental network, and that work that is done in which we support the specialized networks of fiscal officers of YAMP. We have identified matters, situations of international delinquency in which we could create this kind of teams, and ELPAC might help people that have these contacts, that have these investigations, and are willing to investigate and to cooperate so that the joint team can work without having to go through that ordeal that I mentioned and can finish the work successfully. We are here because ELPAC come, and we voluntarily accept it because it's a benefit and advancement in this impulse for the creation of teams as tools against the organized crime. I place here some ideas. Another concept is that there are other interventions, the time and efficacy, and opening of spaces for dialogue and strategic situations. I would like to leave here the issue to the auditorium, and to what extent this measure of ELPAC could we gather these organizations, the operative impact it might have, and how can we structure it and raise it, and not just see the points that require a more concrete attention, but also a funding strategy, the follow-up strategy, rules, conventional and non-conventional, etc. I do not know if any of the assistants or intervening parties has any question, or if in that case, we can continue with some of these points that I think we're here in the air a bit very briefly. From the Eurojust perspective, what measures are necessary at short term to improve the efficacy of the Latin American teams? First, we have to use the phone and file processes. And it seems also important at short term, the task of rendering people aware, and also the training for these two levels. The task of training in the case of professionals is substantiated by doing it, working on it. The advisable would be to have a training through an identification of cases. When the cases are identified, to make a quick effort so that people associated with this effort have the knowledge and the swiftness required to be able to mount up the investigation and the topics that we are investigating. Before getting to that moment, it is necessary that the mind of the investigation, the mindset of the need for international cooperation of the district attorney's office to which that entity reports when it has a transnational problem or pluricontinental problem, lights up a light that there's a connection, to think here is a case that is liable to have an investigation team. There are people that can help with it. There's a network of fiscal officers. There's a reality, there's a network of fiscal officers in YAMP that not only those that are established, but are also a great advancement by YAMP, not only institutionally, but also in the operational part. I have the opportunity to work with some of these networks, and I saw how they work. It's a great conquest. It can be a great leverage for Latin America to generate this product and to have an idea that lights up in the mind of the fiscal officer of the department. There are tools, there are instruments, there are people that can help. As we move on, after talking to Eurojust, in a short term, it's to get the phone, to launch the process where we are, the situation we are not only in Latin America, but also that we find in cases in the European Union. It's this one. Many times, and I'm talking about the Spanish case, our judges of instruction, our fiscal officers, many times they don't have an updated knowledge of the existence of this supports, this counseling, and they do not know how can they have a quick access to them, which they are easily accessible. And what is lacking is to cover this void, placing the information here. Also, it does not make sense to invest in large, massive plans, massive information when you do not know what percentage that people might be assuming in this investigation. It's important to have this awareness, to invest in this impulse, to remember this existence, and to have this cavalry, let's say it, at the back, and that they have the knowledge to know about this possibility to facilitate the task. Dr. Jorge, I'm going to ask you the same question, but in reverse. That is in relation to that cooperation, the strategy from Ibero-American countries to Europe. What is more important in general? Or do you have anything more concrete? I think that our international cooperation units are already aware about this matter, but the problem now is how this can be transported to each prosecutor. Each one sometimes are very zealous about their own investigation, especially those that are more complex. The management of the information. The problem is not the interchange with other countries, but within the district attorney offices. Sometimes they kept reserved by each prosecutor
La información pueda
with the objective of prevent that this can prevent the detention of the criminal. One of the challenges we have before us, how do we can we make that our prosecutors or investigators are available so that their investigation can be shared with the investigation team? Maybe we should need specialized investigators of international scope to create a group of people that have knowledge about the system and that belong to certain organizations and that support the counseling of this organization. The question is, how do we make the title holders of this investigation understand the benefits of this kind of joint investigation? And one of the most urgent challenge would be to try to incentivize investigations, the bicontinental ones, based on the experience that is supported by Eurojust, to convey this kind of experience to the transcontinental teams so that we can convey these concepts to our regional concept for these important decisions. So I think these are the urgencies without prejudicing others that we have signaled along this debate. Thank you, Dr. George. So the last question to start the conclusion. We've seen the short-term requirements. We haven't spoken about the evaluation of joint teams. So where will it take us, or what can we expect on a long term? I think that the exercise of evaluation that is done by the network of joint teams shows that result normally evaluation is done when we finish the joint team, but that result should be evaluated after everything is concluded. But for me, for instance, 1 month ago, the sentence of the first joint investigation team that was constituted in Spain, a joint case that involved Spain and Sweden, and the case, I don't want to talk about details because might be a good example, but it's a joint team that was constituted as such and worked for 2 hours, and they used, because neither Sweden or Spain have limit terms for the investigation. And I think that 4 or 5 years later, I believe that it was a success for Spain because it was able to condemn several participants in that organized crime group, and Sweden 4 years before had released the main person responsible. This team made a follow-up that was not defined. The team had already finished, was concluded. A new relationship was not defined anywhere, but the researcher, the investigator, kept in contact with Sweden because wanted to know the result and the Swedish sentence, which was included in the Spanish process, and helped to finalize the process in Spain. And so this is one of the things that is done, namely in Extremadura. I'm not responsible for those teams, but there's a colleague of my office and are doing this evaluation prematurely because I think it should be done after the final sentence is heard. Because this situation between Sweden and Spain should have been done in a different way, but to know the experience, to understand what is better. And eventually we could have had a different result. I think there's a lot of practical aspects that should be evaluated, and those evaluations should be conveyed through the network through the international cooperation networks so they can be diffused. And then after, if we are the first consultants, then we should also know the good practices to give good consultation and ensure good results. Probably there will be a moment, the experience of joint teams, although it might have started for a long time. No, it started just a short while ago. Maybe we should have a joint exercise, not only just one team, but in general, several teams. Maybe organize a network of teams and then organize a guideline, that manual that might inspire national legislations to regulate everything that is not regulated yet and can be improved. I think that is important. And from that point of view, I talk also about a joint European team. I think the role played by CONGIP is very important to motivate the justice ministries to support the legislation, and that can include all this experience that is obtained from the joint teams to update the legislation so it can be applicable. And it's not an obstacle that only causes ordeals to those that want to work with investigation. Dr. Jorge, it was a pleasure to have you with you.
So following the indications we've had, we are going to conclude this roundtable. Antonio, thank you very much. You all behaved brilliantly. I would like to deeply thank the members of the panel, the participants, the audience, this is the end of this panel. And so now we'll have a coffee break. We'll have a coffee, and then we'll have a walk later on at 8 o'clock. So we close earlier today. So hello, everyone.
Hola, para la cena de esta noche, sí. ¿Va a ser en el mismo? Sí. Hola, hola.
David.
Hola.
¿Vos tenés micrófono? ¿Tenés habilitado el micrófono? Anda,
Venete arriba, a las 8. Bueno, bien, voy a ir a hablar con ella.
Bueno, me parece muy bien.